Ready, Barry?
Okay.
Kurt, you ready?
Yes.
Okay.
All right. We are unmuted.
Yep. All right. You can go ahead and start the prelude into the
Okay.
meeting, and then we'll turn it back over to Barry.
Good evening, everyone. My name is Drew Bilby, planner, and I will be helping to facilitate the Zoom video portion of the meeting. We will work alongside the chair to facilitate the meeting proceedings. I have a few housekeeping items for this hybrid meeting. This meeting is being broadcast and recorded on the city's YouTube channel and cable channel 25. Please remember to mute yourself during the meeting when you are not speaking. The chat function for this public meeting is disabled. All chats will go directly to me. Unless you are participating during the meeting, please turn your video off. This allows the active meeting participants to be seen on screen. You will still be able to hear the meeting. When you are participating, please turn your video on. If you are having any trouble, you can send a chat to me. The city reserves the right to mute people or turn individual videos off to minimize distractions during the meeting, and I'll turn the meeting back over to the chair.
All right. Welcome, everyone, to the July 11th meeting of the Board of Zoning Appeals. First, we need to call the roll to see who is officially here and determine whether we have a quorum.
Okay, good evening, board members. Catherine Week, staff liaison. Harrod,
Here.
Palos,
Here.
Rankin, Shalinski,
Here?
Shanuda,
Here.
and Watkins.
Here.
All right. A quorum is present, so we can proceed with our business. The first item on the agenda is communications. And the first item on communications is to acknowledge communications to come before the board. I would like to acknowledge the fact that I believe all of the board members received an email communication that was directed to us as well as some people on the city staff, received from an attorney at the Pete Fish Law Firm. And there are difficulties because as board members, we don't act as individuals, we act as a board, and we don't communicate with each other or with others outside of the meeting. And so I feel like it's important to know that communications like this have been acknowledged and dealt with, even though we're really not in a position to do that by virtue of our structure. I'm going to ask the staff to comment on this, and we can then see if there's anything as a board we need to consider or think about.
So you were copied on a communication, again, per your Kansas Open Meetings Act training. You should not be responding all to communications that you all are copied on. That, just so you know, that communication was responded by the planning director, did respond to that communication. It was not an item that is before the board, so it is not an item that needs to be discussed by the board. So,
Does anyone have any questions or want any further information or wish to do anything further? Okay.
Point of order, are you taking public comment?
This is not a public hearing item, and our board only receives public comment on matters that are officially before the board, which this apparently isn't really, so.
Well, Mr. Chair, the board gets to decide what comes before it.
Okay,
So, I mean, I would inquire of the board if anybody wants to hear
So,
the
board-
subject of what Mr. Allman wants to talk with us about.
So, Board Member Harrod, actually, that is inaccurate that the board decides what comes before the board. City Attorney's Office has advised us that this is just like any other application process, and so.
Well, let me
some items are
narrow that statement.
Okay.
We can't sua sponte, just bring someone in off the street and hear an appeal. So staff is correct. But the board does get to discuss amongst themselves what they want to discuss among themselves, so long as it's, I think, relevant board business. And if we have a person here this evening that wants to address the board and advise us of something, then I think that we can be advised legally. Can we take action on it? No, I don't know that we can take action on it, but we can be advised. That would be my position.
so in other words, like
One other,
where the city commission receives public comment and says we won't respond, but we'll listen, essentially?
That would be my understanding.
I think Catherine has something to say.
yeah, I think our board is structured a little differently than planning commission or, say, city commission, where we are here for quasi-judicial items. And I would just caution the board members that potentially this item that you're referencing could come before the board and be a matter before you. And at that time, you would be open to discussing that at that time. But I would caution the board discussing it prior to that, if it would come before you. And again, this is not, I mean, we have a meeting structure, and so I would caution the board to stick to the meeting structure. But
Do other board members have thoughts on this that you'd like to express?
You're talking in terms of whether or not we hear them, is the question. Yeah. I'm not sure how I feel about hearing them, but I'm pretty sure I don't think we should be responding in any way. If this isn't, Catherine, if this isn't the forum for them to speak, when would be?
the forum for them to speak about it would be when the item comes before the
When it's-
board.
when an application-
And/or written communication that can be added to the packet. Again, you're a quasi-judicial board, and the agenda is what are the items that you are before you for consideration. And the only reason I'm cautioning you is because you do not want to discuss an item, be it process related to an item or the item that could potentially come before you, which there is the element that it could still come before you, if for some reason action were taken by other parties. So.
I will hear a very brief, non-substantive comment.
Thank you.
So, Chair, I would say you would need to open public comment if you're going to take public comment. And again, our board is not structured to do that, but you would need to open it for public comment if that is your intent.
I mean, I'm new to this board, Chair Shalinski, but I have been on the other side of this process as an applicant. I can tell you that you start opening it up for public comment or substantive discussion without applicants, without the other side being given the opportunity to be notified, to be present, to rebut information. It's a bit, challenging to discuss things that haven't been notified to the public. Just in terms of keeping it clear, concise, especially on issues of importance to the community, it ought to be done properly, in my opinion.
There's also, just to point out, there's also potentially an issue of recusal if you're going to discuss that item. So you would have to weigh that as well.
All right. So what I'm going to do is
Here's what I would
see if
suggest.
there is a
This is what I would suggest. Mr.
motion.
Chair,
Go ahead.
is we have kind of a novel situation before us, the board that we've been advised of. I think that staff and the city attorney should probably come before this board at some time and let us know what's going on with that and close the loop on that. Otherwise, I think it kind of makes the board feel like, it sounds like there's someone that wants to get in front of us, but isn't finding a mechanism to get in front of us. At the same time, I'm cognizant that staff is a little bit caught by surprise tonight that we could be hearing from some people that might have some issues they want to bring in front of us. So what I'm saying is, I don't think, now that the thing is out of the bottle, right, and we have community members trying to get an issue in front of the board, I think the board's wondering, well, what happens? Does this issue get to come before us? How is the issue being disposed of? Because we're here as appointed members of the community to represent the community, and there's a fear that somehow the community is being kept from talking to us. So I don't know that tonight is the night to hear this stuff, because I want staff to be prepared to address this. If the city attorney wants to be present, and I think the city attorney needs to be given an opportunity to come and advise us of their positions. So that would be my caution to the chair, which is perhaps we should not be hearing things tonight, but I think that at some point somebody needs to close the loop on this issue that's been brought before the board in two emails.
Okay. So there's not a motion. And it might be useful if, rather than the substance of this issue one way or another, that there was some sort of procedural discussion that we could have in the future about exactly how things
Yep.
get here.
Staff Liaison Catherine Reed. So some of the issues are in your yearly training, which is in October. And we can go over some of that again when October rolls around. But relative to this and to the policy issues, again, I touched on it briefly in that this is very similar to items that are not under your purview, where there are items in the code that are not under your purview that are not eligible for variances. We do not bring those before the Board of Zoning Appeals. Even if someone were to submit an application for that, we would not bring it because it's not eligible. This is a similar situation. It happened a little differently, but it is a similar situation. And again, as far as closing the loop, all the appropriate communications have gone out from the city to the individuals who are involved. And we can certainly have the city attorney come at the next meeting, and they can discuss anything relevant as far as, questions you might have about that process. So
Okay.
we can schedule that for the next meeting.
Yes.
Yeah. Catherine, can you remind us what the director's or the attorney's position was on this item?
So there was an item that was determined, that was filed before the Board of Zoning Appeals, accepted by the Planning Office, and it was determined by the city's legal department that That item was actually not eligible or under the purview of the Board of Zoning Appeals based on whether or not it was a valid application or the person was a valid party aggrieved. So,
Okay.
And that was communicated.
that was absolutely communicated. There are multiple letters that have gone out. We've even had open records requests, so those letters are out there. So, yep.
Okay. I think we probably gone as far as we can go tonight on this and maybe further, so. B, disclosure of ex parte communications or abstentions for specific agenda items, and there's only one specific agenda item tonight. So if anyone has received any communications or wishes to abstain on this item, please put that on the record. Okay. Finally, C, announce any agenda items that will be deferred. And I've not heard that tonight's public hearing is being deferred. Is that correct?
That would be correct. Yeah.
Okay. Then let's get into the agenda. This is a request for variance, B 241001. And this is a multi-part variance request for a property located at 2350 Franklin Road, submitted on behalf of Tony Alessi, the property owner of record, and I'm not going to read all 5 of the requests, but it is before us, and we are prepared to hear this item. I guess we will start with staff giving an overview, then we'll hear from the applicant, and then we will hear any public comment if there is some.
Okay. Good evening, board members. Oh, sorry, go ahead.
Hi, Board Member Rankin, could I jump in? With this being a multi-part, is this like all or none? Or is this, can we?
Yeah, so staff liaison Catherine Week. So it is a multi-part variance. It's all one packet, but you will need to make 5 separate votes on each individual variance section. So I think Drew was going to get to that as part of his synopsis of his presentation. But yes, it will be 5 votes for the.
Sorry about this.
Yep.
No problem. Okay. So good evening, board members. Again, Drew Bilby with the Planning and Development Services Department. As mentioned, this is a multi-part variance. The variance number is BZA 241001 from Articles 9 and Article 10 of the Land Development Code. The subject property is again located at 2350 Franklin Road. The applicant is proposing to establish an RV and boat storage use on the property. As part of the major site plan process, the site is required to come into full code compliance. The applicant is seeking the 5 variance due to site constraints. The first variance is from section 20-905C1 to reduce the parking setback in the limited industrial zoning district from 15 feet to 0 feet. The second variance is from section 20-1002B to reduce the required number of street trees from 5 trees along Franklin Road to 0 trees. Also to reduce the required number of street trees along Thomas Court from 6 trees to 0. The third variance is from section 20-1004C to reduce the required perimeter landscaping of 2 trees along both Franklin Road and Thomas Court to 0 trees each. The fourth variance is from 20-1004C to remove the requirement that the parking lot be screened with a solid masonry wall with a minimum height of 3 feet and a maximum height of 4 feet, or a berm with a minimum height of 2 feet and a maximum height of 3 feet and a maximum of 3-to-1 slope, or a continuous row of evergreen shrubs with a minimum height of 3 feet. The fifth and final variance is from section 20-1004D to reduce the required perimeter parking lot landscaping area between the off-street parking and the Thomas Court and Franklin Road rights-of-way from 10 feet to 0. I will now briefly run through the 5 review criteria. Criteria number 1 focuses on unique site conditions based in platting or zoning. This variance originates from the applicant's desire to pave and stripe the existing RV and boat storage location. The existing parking lot encroaches into the right-of-way of Thomas Court. The applicant is proposing to bring the parking lot into the property boundaries. The subject property is a platted lot of record. There has been no official submittal for this site for the RV and boat storage use that exists today. As such, a site plan for this use must fully conform to the Land Development Code. The property has been non-compliant since December 2022 due to the non-site planned vehicle storage. Staff held off on code enforcement as a courtesy for all of 2023 to allow the site to complete steps to come into conformance. The subject property is the smallest property in the nearby industrial zoned area, but still meets all of the density and dimensional standards that are required for lots in the limited industrial zoning district. This district requires a 15-foot setback from right-of-way when providing parking. If the parking lot followed this setback, the lot would have roughly 1,000 square feet less of parking area. To conclude this section, staff believes the subject property does not exhibit conditions of uniqueness based in platting and zoning and does not warrant the variance from the city standards. Criteria number 2 is potential adverse effects upon the rights of adjacent property owners or residents. In staff's opinion, the requested variances would not adversely affect the rights of adjacent property owners or residents to maintain their existing land uses. However, the granting of these variances could create an adverse impact on the rights of adjacent property owners due to the fact that there are no unnecessary hardships present. The granting of these variances could afford this site benefits that were not given to the neighboring lots when they were developed. All nearby undeveloped lots will require major site plans that will require full code compliance as well. Granting these variances could create an unfair allowance for this site. Criteria number 3 deals with unnecessary hardship. In staff's opinion, requiring a minimum level of compliance with the off-street parking standards and landscaping and screening standards for a major site plan is not arbitrary or capricious, does not interfere with the basic right of property ownership, and does not constitute an unnecessary hardship. All properties in the limited industrial district are required to meet the same code requirements. The applicant's requested variances are not unnecessary hardships. Rather, they are density and dimensional and landscaping/screening standards that, if provided in a compliant manner, would restrict the possible RV and boat storage spaces that the applicant could provide. The applicant has not provided any valid hardships. The variances would maximize the amount of parking spaces they could provide on their lot. These variances requests effectively waive the applicable code sections to accommodate a use that was not site planned and thus had no standards of review in the past. Criteria number 4 addresses adverse effects on public health, safety, morals, order, convenience, prosperity, or general welfare. The parking area setback is intended to create a modest landscaped buffer area between an off-street parking area and the adjacent rights-of-way and properties. The 15-foot requirement aligns with section 20-1004D of the Land Development Code, which requires a 10-foot buffer area between the off-street parking area and the street rights-of-way. This area is intended to hold parking lot perimeter landscape materials and may also hold street trees. Off-street parking area setbacks also support pedestrian safety and comfort along adjacent sidewalks within the public rights-of-way. Finally, the 10-foot distance allows for space for at least one vehicle to temporarily queue out of the roadway if the off-street parking areas, access aisles, or parking spaces are blocked. The space is also used by exiting vehicles to safely check for oncoming traffic before entering the roadway. A newly constructed off-street parking area must be properly set back in order to support landscaping, screening standards, and vehicle and pedestrian safety within both the public rights-of-way and subject property. Criteria number 5 is the general spirit and the intent of the code. The applicant originally applied to repave the existing lot, but staff determined that the site had never been site planned, so the applicant was required to submit an official site plan, and with that site plan, the variance is requested due to the site needing to come into full code compliance. The lot is currently out of conformance, and the requested variances are waiving code sections, so the site will not have to meet them. This in itself is not the intent of the variance section of the code. Variances are designed to alleviate loss of rights due to unnecessary hardships. In staff's opinion, the applicant has not provided any unnecessary hardships. The lot itself meets the minimum standards for the limited industrial district, and the use is permitted in the district. This provides an applicant a clean slate to establish the permitted use, and thus they must be fully code compliant. Variances carry through ownership and are tied to the land itself because it is assumed that the land creates the unnecessary hardship. In this case, the land does not create any hardships. The purpose of the variance process is to equalize the development process for properties. Variances are intended to mitigate unique site conditions based in platting or zoning and allow for the productive use of a property. The variance process should not be used to increase the storage capacity of an RV and boat storage use. The subject property is moving towards compliance via this major site plan process by bringing the parking lot inside the area of the property boundaries. It has functioned as an RV boat storage use for at least 10 years. A variance to achieve more storage spaces in a new parking lot is not appropriate. The surrounding area is inhabited with various industrial uses, and the RV boat and storage use would fit in this area. However, the use is not being infringed upon by the code. The applicant could still provide storage spaces for RVs and boats with the code-compliant parking setbacks and landscaping screening that is required. To conclude, staff's analysis of this variance application finds the request does not meet the 5 conditions set forth in section 20-1309G1 of the code that the board must find existing to grant a variance. Staff is recommending denial of the multi-part variance request from Articles 9 and 10 of the Land Development Code for the property addressed as 2350 Franklin Road. And as Catherine mentioned, there will be a vote for all 5 of the proposed variances, and staff is recommending denial of all 5 of those variances. That concludes my presentation. I am available for comments if you have any, and I will turn it over to the applicant if they are present.
Okay, do any of the board members have any questions for staff?
I do.
Okay.
I understand from what you read just now and what was in the report is that there was never a site plan filed for this development?
No. So this was originally part of a planned industrial development, but was never developed with that that project.
Right.
It was just remained vacant. Sometime in the last 10 to 15 years, it was developed with this vehicle storage without a site plan. And so now, to become code compliant and in conformance, they are needing to do this major site plan process.
Well, my question is kind of leading up to, so the development to the east of this, the enclosed structures, the storage facilities, were they site plan approved?
I believe so.
Yeah,
They were.
The rest of that plan development has developed according to that original plan. This was kind of the parcel left to be developed later.
Okay, I understand that. I wanted to be sure I understood the relationship of the two. Well, I just wanted to note also that that development doesn't have any landscaping around the fence perimeter.
There used to be a house there and tore it down.
Is that it?
Mm-hmm.
Okay. But So still no trees required or no landscaping?
So, yeah, Drew might be able to answer this better, but as he mentioned, that plan for that development does have a landscaping plan. If they are not in conformance, that would be something that would have to be addressed as well, separately from this property. They're under different parcels now, so, but there is a plan, and it does have landscaping, so.
Okay.
The way I understand it is that the rest of the property doesn't fit the code for plants and et cetera, landscaping. So if he does move forward, he has to bring that up to code with planting. Just because he built it 10, 15 years ago and didn't have to do that, he's required now to do it.
Yes, that's correct. Essentially, it was built either without a site plan or I'm not sure how it came about because we did not have anything on file for this this parcel in question, the 2350 Franklin Road. But yes, essentially to move forward with the paving and the striping that they want to do that is required. It is a major site plan process which requires them to build and install the landscaping and the setbacks.
Got you.
Okay.
Any other questions for the staff at this time? Okay, let's hear from the applicant.
I don't see anyone online. Did you want to speak about it at all? or-
Is there anyone present representing the applicant, either in person or on Zoom?
Not seeing any.
That's unusual.
Okay, I guess we will call for public comment then. Is there anyone
Yeah.
you'd like to comment? Okay. Please identify yourself and tell us what you would like to say.
Okay. My name's Roger Johnson. I developed this area.
And when you say this area, are we talking about, because I'm looking at it,
It's 40 acres. I developed the whole 40 acres. I split it up in lots.
and so like the ACE bail bonds and the storage places and
I own the property on the east. I own the property on the north. You know, what they did is when I sold that piece of property, there was a house on it and they did their mini storages. And then they tore the house down. Then they just gravelled the lot. And then they used to park junk cars on it, wrecked cars. So then the county, or the city got on them about that. And then they tried to turn it into a storage lot. But all the other buildings around there, you know, we put in our street trees, we put in our setbacks, we put in our water retention. And now they think they can just do that and they want to move everything out to the curb. You got Franklin Road, which is an arterial street, which is going to lead to all of the development going south. I mean, this doesn't make sense. I don't know why they think they can do this. You know, it's like you said, it hadn't been in compliance forever, and it's looked like shit. You know, the rest of us, we pick up the trash from the homeless shelter, we mow the grass, we keep that area looking right. You know, I've been meeting with the city on a regular basis because of the bus stop. Everybody knows the bus stop's there, right? 2 days ago, I got a confirmation from the city to move the bus stop to the homeless shelter. So that cleans up that area, but this just junks it up. And if you let them do this here, are you going to let me do the same thing with my other 5 lots that are beside it? That's my question. You know, when we set this up, when we developed this, we had these codes we had to live under. But these guys want to take this 1 acre piece and screw it up.
Mr. Chair, can I inquire of the speaker?
Yes.
I just want to make sure, because I'm hearing, maybe a little less on the cursing. I know I'm tempted to sometimes as well. But your staff was just now talking about to allow this variance gives this applicant the ability to do things the other people around him can't do.
That's correct.
Do you agree with that?
That's totally correct.
Okay, all right. I just wanted to make sure, so you're lockstep with staff on that point at least.
Right.
For sure.
And my last question is, okay, you let them do this. When I do these next 5, I'm going to expect the same treatment.
If a variance was granted
Yeah.
tonight. Right.
I mean, it's not fair. You know, I developed this to be something for our city. And we have a nice street going south, because eventually that's where the growth going south is going to have to go down the street. Let's not junk this up.
Right.
That's my complaint. You know, plant your trees, do your screening. I mean, I've done it with all my buildings. Look across the street what we did. I mean, the city's been on them for, I think, Catherine, 2 or 3 years. They used to park wrecked cars there, and finally they got that off, and then they're parking RVs and boats and whatever else they can get by with. And they're not in their setbacks. They're way out of their setbacks.
Thank you.
All right, Mr. Johnson, we appreciate your comments. Any other questions for him?
No, I just comment that traveling around there, it looks pretty nice with the exception of that one piece of property. There's
I worked my ass off.
mature trees and, yeah, it's very nice.
You know, I had the development out there, we're doing the housing. And the bus stop has just caused a tremendous amount of trouble.
I didn't know that.
And so I worked with the city, I worked with the bus people. Finally, on Tuesday, they said, okay, we'll move the bus stop to the homeless shelter. And that cleans up that whole area. I even offered to pay to move the bus stop. I said, I pour your concrete, I'll take your little shelter down, I'll put it back up. But they decided to move it on their own. I offered to pay for it, to keep our area where it doesn't look junky.
Very good. That's great to hear.
All right. Are there any other public comments? Anyone on Zoom? There's no one in the room. All right. I would entertain a motion to close the public hearing portion of this item.
So moved.
So, second.
Okay, moved by Herod, second by Palos. Do we need to call the roll, or can we take a voice vote on this?
I think you can voice vote.
All in favor?
Aye.
Aye.
Okay, public hearing is closed. So, let's bring this back for board discussion. I will just start briefly by saying that, as I always do, I went and looked at the site, and that's the first time in a while that I've been to that exact location, and there is a lot of new housing going up. But it is still, I won't call it undeveloped, but it is a developing area. And the thing that I always keep in mind about variances that we grant, according to our rules, which I don't like and don't agree with, but it's still the rules, once you grant a variance, it is forever to whomever owns the land and for whatever purpose they might decide they want it. And as I look at what's there and what might be there, what could be there, and the thought of the permanence of this, I just can't. So that's my position. Other thoughts from board members?
Well, I, beyond just the fairness of it, I think it's important that people adhere to the county's and city's regulations. And it seems to me that this person has not been doing that. And it's unfortunate that he's not here. I would like to hear his explanation. But I'm ready to make a motion on this.
Okay,
All right.
I'm ready to receive it.
Did staff say we had to do this one by one?
Yeah, there'll be 5 votes.
All right, well, I make a motion to deny variance for the first item because it doesn't meet the 5 criteria.
I second that.
Okay, there's a motion and a second, and the first item would be,
That would be,
Reduce the parking setback
It's the
from
parking
15 to
setback.
0 feet.
yeah, correct.
okay. Is there any discussion, or are you all ready to vote? All right. Staff, please call the roll. The motion is to deny the parking setback request for variance.
Okay. Harrod?
Deny, yes. Aye.
Okay. Palos?
Aye.
Rankin?
Aye.
Shalinski?
Aye.
Shanuda?
Aye.
Watkins?
Aye.
All right, motion carries.
I move to reduce the required number of street trees from 6 trees along Thomas Court to 0 trees. I move to deny the variance to reduce those.
Second.
All right, moved by Watkins, second by Harrod. Any discussion? All right, staff, please call the roll.
Okay, Harrod?
Aye.
Palos?
Aye.
Rankin?
Aye.
Shalinski?
Aye.
Shanuda?
Aye.
Watkins?
Aye.
And that motion carries.
All right, so item number 2 is denied. Do we have another motion?
I move to deny the variance request to reduce the required perimeter landscaping from 2 trees along Franklin Road and Thomas Court to 0 trees.
Okay.
Second.
So moved by Watkins, second by Rankin, with regard to the landscape tree requirement. Staff, please call the roll.
Okay. Harrod?
Aye.
Palos?
Aye.
Rankin?
Aye.
Shalinski?
Aye.
Shanuda?
Aye.
Watkins?
Aye.
And that motion also carries.
All right. And do we have another motion?
Keep rolling through these. I move to deny the requested variance to remove the requirement that the parking lot be screened with a solid masonry wall with minimum height of 3 feet and a maximum height of 4 feet, or a berm with a minimum height of 2 feet and a maximum height of 3 feet and a maximum 3-to-1 slope, or a continuous row of evergreen shrubs with a minimum height of 3 feet.
I second.
Okay, so that was moved by Watkins, second by Shanuda, to deny the perimeter landscaping, parking lot perimeter landscaping variance request. Staff, please call the roll.
Harrod?
Aye.
Palos?
Aye.
Rankin?
Aye.
Shalinski?
Aye.
Shanuda?
Aye.
Watkins?
Aye.
Motion carries.
All right, I think there is one more.
Anybody else? I'll do it.
Go ahead.
I move to deny the specific request to reduce the required perimeter parking lot landscaping area between the off-street parking area and the Thomas Court and Franklin Road rights of way from 10 feet to 0.
I second.
All right, moved by Watkins, second by Harrod, to deny the fifth variance request regarding parking lot perimeter landscaping.
Okay.
Staff, please call the roll.
Harrod,
Aye.
Halos,
Aye.
Rankin,
Aye.
Shalinski,
Aye.
Shanuda,
Aye.
Watkins.
Aye.
And that motion carries.
All right. I think we already dealt with one pretty weighty miscellaneous item. Are there any others to come before the board?
Mr. Chair, could I speak briefly into the record regarding my pending expiration of my term?
Oh, please.
Thank you, Mr. Chair. I wanted to get a chance to speak into the record because we haven't been meeting much lately. So it could very well be that my term will expire after September, and so I might not be back before you again. And if I do this now, it'll also make for a shorter meeting in August or September. So I wanted to let all of you here know, and all those people that I served over the last 6 years with on the Board of Zoning Appeals, let them know my admiration, my respect, my appreciation for you guys coming here and considering these issues. This is a statutory board. They have to have it. They can't not have it. And the fact that we, over and over 6 years, get, find people from the community in here to listen to these items and make decisions on them, you have my respect. Regarding staff, we have good planning staff in the city of Lawrence, and I've had a chance to work with them not only in here, but in other areas. They're great. Specifically, our staff liaisons here. I know I've done stuff over 6 years to make them scratch their heads, furrow their brows, maybe even more than that. However, they should know I have never for a second doubted their competency, the quality, and just the excellence of their work. They do amazing work. They give us great technical advice, and I have always been deeply, deeply appreciative of the staff liaisons that come in here and have to wonder, what are we going to get into tonight? And so I wanted to make sure that, and hopefully, maybe Jeff will watch this on YouTube and hear me praising the staff liaisons over the last 6 years. So I wanted to make sure to get that into the record. So that being said, this will make the meeting in September 5 minutes shorter.
All right. Well, I'll make it 1 or 2 minutes longer by saying that I've always appreciated your thoughtfulness, your listening to all sides. I've learned a lot from you, and you did this chair gig that I'm doing now for at least a couple of terms, and did a great job of it, and that was my model. So thank you.
Thank you, Barry. Thank you. Thank you. Thank you, everybody. Thank you, sir.
So I do have a little bit of miscellaneous when we're ready. So.
There's more.
Yeah. So normally I like to give miscellaneous, during this time, give you a heads up if we're going to have another meeting or items on the next meeting. We have a couple that are inquiring, so if not next month, we will definitely have one, I think, in September, but I anticipate there may be one, at least one next month. Also, just a little bit of updated information for you. I know you all were aware they were doing the whole board consolidation thing. That has gone to completion. Staff reiterated that our board is a statutory board. It doesn't really make sense to get rid of a statutory board because we don't really have the authority to do so. So our board remains the same structure. I don't know if you saw in the updates the city put out, but the other boards, their memberships basically ended, and then they are being reappointed to the boards that remain, but our structure stays the same. So there's no changes there. One other thing I want to point out about that is, though our structure didn't change, we may need to look at our incorporating resolution and just our policy procedures and make sure that they align with how the city overall is going to be onboarding or training the new board members. And we may have to tweak our resolution just to make sure that, for instance, just our procedures are in line with the city's procedures for boards in general. It wouldn't change any of our statutory requirements, but maybe some small procedural things like onboard training or things like that may come into alignment. And just as a refresher, we have a training as well as elections every October. That is still planned for this October. Everybody's had the training, but we like to do a yearly refresher. That's when we do the COMA and all of that. So I think either for the next meeting or possibly in September, we may have some information on whether or not our resolution or ordinances need to be tweaked. And those would require board votes to change our documents. So that's the heads up that I have there. But otherwise, we proceed as we always have. So, yeah.
All right, thank you.
Yep.
Anything else? Yes.
Yeah, just, staff, any update on the lawsuit that was filed against us?
So yeah, there was an update on that. I think I gave it at the last meeting, or maybe not. That kind of ruled in the board's favor. There was some inklings that may be appealed. I have not heard any update to that, or not appeal. And Patrick, you might have the better language. I don't think it's technically an appeal. It's something else.
Motion to reconsider.
Motion to reconsider. Thank you. But I have not heard an update on that. So
Judge has not ruled.
okay.
What does that mean?
It's like the preliminary step before you can file an appeal at the Court of Appeals. You ask the judge to reconsider, and oftentimes the judge reaffirms their position.
Travis, you probably could have given the terminology as well. I am not a lawyer, by the way.
Nope. He gets to be the new guy to do that.
Well, I'm too close to that one.
Yeah. So that's the update there. So we're just kind of waiting to see if we get notice or anything. And the city attorney will keep us informed, so. That is all I have for miscellaneous items.
And I suppose that if they end up changing the parking requirements so there are none, then the whole thing will become moot.
We'll be almost out of business.
Yeah. Okay. Do we have a motion to adjourn?
So moved.
Second.
Moved by
I think.
Herod,
yeah.
second by Palos. Call the roll, please.
You can have a voice vote on that.
Okay, all in favor?
Aye.
It sounds like
All right.
motion carried.
Meeting adjourned. Thank you all.
Thank you.
Thank you all.
Well, Patrick?
Thank you for the kind words.